The other big legal battle that's been brewing for some time in Indiana is over right to work. The legislation bars unions from requiring employees to pay union dues, and 2.5 years after the measure passed the Indiana General Assembly, legal challenges to that law are coming to a head. This week, the 7th Circuit Court of Appeals upheld the law, and the Indiana Supreme Court heard a separate lawsuit. In just a minute, we'll discuss what that means for workers. But first, some background. When the House and Senate considered right to work in 2012, hundreds of union workers and their families gathered at the State House in protest, saying the law would cripple unions. They said it would pit union and non-union workers against each other and drive down wages. But supporters said it would attract much-needed business to the state.
It doesn't just affect me, it affects all these people here that are raising families. You know, each of us here has kids and wives, and we make a great living in our union. We work hard for our union, and we pay our taxes, and we vote.
This bill is right for Indiana because we're going to create jobs out of this. Our unemployed Hoosiers are going to be able to find some opportunities to get back to work, and it's a big plus for the state of Indiana.
It's still too early to tell exactly what effects right to work has had on Indiana's economy, but right now the more pressing question is the law constitutional? To help us answer that question, we turn to Indiana labor and employment law professor Ken Dau-Schmidt. Thank you very much for being here. Let's start with an explanation of each side's main arguments. We'll start with the plaintiffs. In this case, it's the International Operating Engineers Union that filed the lawsuit. What's their side to this?
Sure. Their problem, under federal law, we have an election system for determining whether or not workers are represented by unions in our country. And if the union is elected, they are legally obligated to represent all the employees in the bargaining unit, whether they are members of the union or not. They have to provide them, they have to represent them in bargaining, they have to represent them in grievances, they may even have to hire a lawyer to represent them in grievances. And this can be quite costly, and they can be sued if they don't represent non-members. And the problem with this is it's an electoral system. There are certain advantages to the system. It simplifies bargaining, and it makes sure that the workers actually want the union when they elect it. But the problem is that it leaves the union with a very tough business model. We are required to provide services, but we don't necessarily get to collect dues because you don't have to be a member. And the solution to this has usually been to negotiate what are called fair share agreements. The union negotiates with the employer that as a condition of employment, all employees, whether they're a member or not, have to pay for at least the costs of representation in the unit. They don't have to pay full dues, they don't have to be members, but they have to pay for the costs of representation in the unit. And the union's claim there has been that this is, under the Indiana Constitution, this requires the provision of services without just compensation, and that's a takings under the Indiana Constitution.
And then let's talk about the state side of this. What are the attorneys saying to prove that it is constitutional?
Well, there's a variety of constitutional arguments here. Some of them are First Amendment and equal protection arguments, and the union's argument there is basically when you require us to provide services and our members have to pay for it, non-members don't have to pay for it, you are burdening the non-members, or burdening the members. And those arguments were the arguments that were made in the federal court, those are the arguments that were made in the state court, and they were dismissed. The argument that prevailed in the state's courts was the takings clause argument, and there Indiana has a fairly unusual takings clause provision that says not only can't you take property without just compensation, you can't require people to provide services. The state, in trying to argue, they would say it's not the state law that's requiring you to provide services without compensation, it's the federal law that's requiring that, and that's largely what they've hung their hats on.
And let's look a little bit broader. There are 24 states now have right to work laws. Is there anything different with those states compared to Indiana?
Well, those state statutes have sometimes been challenged, but what's different in Indiana is this broad takings clause. There's only one other state that has a takings clause as broad as ours, and it's interesting because the takings clause is basically a conservative clause. It's saying the state cannot do something, it cannot take my wealth without compensating me, and so you'd think this might be an argument that would appeal to conservatives.
We have like 5 seconds left. Any idea of what the court may end up saying here?
I think that I actually, trying to look at it impartially, I think the union has a pretty good argument, but the government has the advantage that there are 4 Republican appointees, 3 of them from Governor Mitch Daniels. So basically we have the Daniels court deciding whether the Daniels legislation is constitutional. And I think they're good justices, but they were picked for a reason. They were picked because of their worldview, and that worldview will probably prevail and the union will lose.
Thank you very much.